Hi there, you're watching BloombergQuint, and this is the fine print. India's competition regulator has found itself in the middle of the litigation battle between Amazon and Future Retail. Soon, the CCI will have to take sides, and that'll entail the regulator having to review a decision it took back in 2019. Here's a quick recap of what's led to this situation. In 2019, the Competition Commission of India approved Amazon's 49% investment in Future Coupons, a promoter entity of Future Retail. The regulator's order had also noted that certain intra-promoter group transactions will precede Amazon's investment. That is, an acquisition of 7.30% stake by Future Coupons in Future Retail. In its order, the competition regulator had done an assessment of overlapping businesses of Amazon and Future Retail. It found no competition concerns in either the B2C retail market nor the B2B sales, Amazon branded services, digital payment, and online marketplace or online intermediation services. And so the CCI had approved Amazon's investment in Future Coupons, saying it's unlikely to cause any appreciable adverse effect on competition. It's this approval that Future Retail's independent directors are now asking the CCI to revoke. How is the regulator likely to respond to this ask? To answer that, I'm joined by two competition law experts, Karan Chandhiok and Rahul Singh. Karan, Rahul, welcome to the fine print, and thank you for finding the time to speak to us on this very curious situation. Karan, I'll state first for the benefit of our viewers the case of Future Retail's independent directors, and then I'll come to you. In brief, the independent directors have disclosed a draft shareholders agreement and internal emails between Amazon and Future Group and their lawyers. Their case is that Amazon sought to achieve from this investment was very different from what it told the CCI back in 2019. That Amazon told the regulator that it's interested in the gift cards business of Future Coupons, but the internal emails reveal that Amazon was only invested in Future Retail. Karan, I'll come to the specifics of this case in just a bit, but can you explain first the law, what amounts to material non-disclosure under Competition Act, and what could be the consequences of it?
Nice question for having me. But I think just to answer questions on what is material and not, what we consider material from combinations, which is merger control, where parties come to the CCI and take approvals, whether or not they can go for a transaction, depends. What is material is what disclosures they make to the CCI, because the starting point for the CCI is the form or the notice you give to the CCI on which it starts its line of inquiry. Now, but the CCI is not restricted to that, what is there only in the notice or what the parties submit. The CCI is expected, in fact, to go beyond and see what is the state of competition in the market, and then come to a determination whether there is an appreciable adverse effect on competition or not. And for that purpose, it does one of many things. One is its own assessment of the market. It may be its own resources. Second, it may ask parties for clarification. Now, in this scenario, if you see, and I know you didn't want to go into the specifics, but specifically, as far as this is concerned.
But before you get into specifics, Karan, I do want to ask that does the Act itself envisage situations where the CCI can invoke a section and say that, hey, look, this allows me to revoke an order? Because rather all orders under merger control do mention that the approval is based on the disclosures that the parties have made. So I want to first understand what the law says in terms of revocation of orders.
Okay, sure. So as far as revocation is concerned, I think the law itself is silent. The law does not actually say anything in the statute book which says that I give you, the CCI, the power to revoke orders if you find tomorrow there's a material non-disclosure. What it does do is or rather how the practice is also involved, is one of many things. One, you could see that the order itself, each order of the CCI approving a combination says that if tomorrow I find out that there is material non-disclosure or this is based on wrong facts, this approval will stand revoked. Now, it's almost like the CCI is saying that every order of mine is a conditional order, conditional upon the parties making full and frank disclosures as to what the materials that they presented to the CCI. So under perhaps an inherent power of the CCI, they could look to revoke orders. Number two is there is section 45, The section 45 deals with the scenarios where parties have either withheld or misrepresented or given false information to the CCI. Now, in that scenario, the CCI has the power to fine parties for such non-disclosure or failure to making incomplete disclosures. But also, there's a residuary clause which allows the CCI to pass any orders it deem fit. And it is perhaps under this provision is where the CCI is thinking of perhaps that it has the powers of revocation. Now, again, this is untested. There's no precedent around it. But I think I just wanted to flag one important point. Under the Competition Act, once a transaction has closed, 1 year from closing, the CCI's jurisdiction to sort of unscramble that transaction goes away. Under Section 20, it does not have the powers to look into the transaction anymore. What it does have the powers to do is to fine or penalize a party for failure to notify that transaction. Now, so if you're in a scenario where here you have a scenario where there's a question whether material information was given or not, but you could have a completely different scenario where parties did not notify the CCI at all. A year has passed since closing, and the CCI's jurisdiction does close. And I think the intent of Parliament was to limit the CCI's jurisdiction in revoking such where mergers have already taken place, acquisitions have already taken place. So that will be a limiting factor.
Yeah. So Karan, thank you for sort of laying the background in which all of this can unfold in terms of the law. So now let's examine whether or not Amazon actually hid anything from the CCI, given what the facts are in the public domain. The independent directors have pointed to certain emails between Amazon's legal head in India and Jeff Bezos to make their case that what you, Amazon, told the CCI in 2019 was very different from the intent that has now emerged from these email interactions. One interaction says between Amazon's India legal head and Jeff Bezos, and this is as per the disclosure that the Future Retail independent directors have made to the stock exchanges, that due to the recent press note 2 restrictions under Indian foreign investment laws, we will use a twin entity investment structure to invest in Future Retail. It went on to say that our shareholding in Future Coupons will be divided into voting equity share capital and non-voting equity share capital, though we will have all the statutory rights available to a 49% shareholder. And as long as Amazon holds at least 33% in Future Coupons, it will get the following rights vis-a-vis Future Retail. Appoint observer on the board. Future Coupons will need Amazon's prior consent, written consent, if Future Retail decides to raise funds from Amazon's competitors, transfer its retail assets, etc. Rahul, let me come to you, and I have a very simple question. Given that the CCI order makes references to the FRL and FCPL transaction preceding the Amazon investment, is it safe to assume that when CCI's approval was sought, all the shareholder agreements were disclosed to the regulator?
Well, thank you, Payaswini, first and foremost, for having me here. I think intuitively the answer seems to be in the affirmative, yes. And I'll tell you why, because we have seen over a period of time, Competition Commission in India is not anymore a nascent regulator. We have seen that Competition Commission has now looked at around 800 merger control cases, and any lawyer who has represented any of the parties at the Commission, they know that, the Commission seldom gives an approval right at filing the short form or the long form. In fact, the Commission largely has the proclivity, so as to speak, about asking follow-on questions. Based on all of those assumptions, my guess would be that they would have asked for much more follow-on sort of clarifications from the parties. CCI would not have stopped just at the threshold of either Form 1 or Form 2 filing. And therefore, based on all of these practical aspects, I would assume, and I would err on the side of assuming, that all of those transaction documents were disclosed to the Commission. I would be very surprised that Commission gave an approval without any of those transactions being submitted to the Commission.
All right. Okay. Karan, Wayne here, do you also have, let's say, the same reading of the facts. And I ask this because the basis on which independent directors are ceasing CCI's intervention is that Amazon said that I'm interested in the future coupons business of brand cards and loyalty cards, etc. But while all along, its intent was or interest was in future retail's assets. When I, as a party, am going for the regulator's approval, I will tell the regulator a story. Given that the facts are not being hid from the regulator, I will tell you that, hey, look, these are minority protection rights, these are not strategic rights. But CCI in the past, we have seen, has observed that, hey, look, you as a private equity investor have your board member in a competing business already, so you have to either relinquish your board seat in that competitor, or you don't get a board seat here. So they go into the kind of rights that the acquirers are getting in great degree of detail. And hence my curiosity that will CCI now look at this order and be able to say that, Amazon, you told us a certain story, we bought it, even though you had disclosed all the facts to us, assuming they did, and now we will, let's say, revoke our approval.
I think personally that the CCI will have its task cut out if it wants to revoke this, because honestly, if you look at the way they have worded their own order, and well, let's not speculate as to what was provided or not, we are just going by the order as it is. The CCI first breaks down the transaction, what's the proposed combination, which is the notifiable part, into 3 different transactions. Transaction 1, 2, and 3, which includes the inter-promoter transactions that is taking place, future coupons, buying shares, or future retail. Now, as you mentioned earlier, there was also a board observer being appointed, and that the way the CCI reads control under Competition Act, the mere fact that you have an observer will grant you control. Second is again, the clues are in the wording. If you're future coupon and you're disclosing yourself as a promoter entity, but promoter by definition would mean you're in control. And so, and more importantly, because these transactions, the way the CCI order reads, to go back to combination regulations, which is the regulations which stipulate the process, they say that if you're a series of interrelated transactions, you will notify on the first of those transactions and make sure none of those transactions take place till you have the CCI approval. So it seemed, at least from reading the order, that none of these transaction 1, 2, 3 actually took place till the CCI approval came. So every party was in the know as to what is taking place when and what approvals are required to take place. And third, the CCI actually does a full competition assessment. They do an assessment of Amazon on one side and future retail on the other side, and looks at other affiliates also. So the legal standard, which is whether this is going to cause an appreciable adverse effect on competition on the basis of the factors given in the law, that exercise was actually done. So when you've sort of ticked most of the boxes, it really, that's why I said that the CCI will have its task cut out to actually pinpoint what was the material misrepresentation made or disclosure that was incomplete, which could have led it to a different outcome as far as this approval is concerned.
Okay, Rahul, coming here, do you believe that, given the same set of facts, I can tell the regulator a story, and the regulator can have its own theory based on, its assessment of where the rights that I'm getting could lead me to, or what could they mean eventually in the long run? Because it's not the case of the independent directors that Amazon hid material facts. What their case seems to be that it hid the intention that it had when the investment was made, that the interest was in future retail and not really in future coupons, brand loyalty cards, business, etc. From a purely legal standpoint, to your mind, does any of this look like material non-disclosure? And does it matter what the story is being told as long as I'm disclosing the facts?
I'm going to go back to, let's say, the legal standard of review point. Regardless of whatever a party might disclose before the Competition Commission, the powers of the Commission are fairly wide, even hypothetically, if we assume that these independent directors, after what, 3 years, I think the way you read timeline, Pius, 2019 is what you said, if I heard you correctly. I think after 3 years, they have woken up. Looks like they are the modern day Karan, and then they probably sleep for a few years and then wake up, right? Assuming that they have woken up after 3 years to figure out that something was going on. Well, I mean, insofar as the Competition Commission is concerned, if the Commission felt that there was something not being disclosed, the Commission has the powers. And in fact, in all cases, the Commission has not hesitated in exercising those powers and asking for additional information from parties until the Competition Commission is satisfied. The approval doesn't come through. I'm sure any lawyer worth his or her salt can tell you it's not, it's not a cakewalk to just get an approval from the Commission unless you satisfy all the fact situation which the Commission is asking you about. And therefore, I mean, I find it slightly surprising that, anybody is making a claim today that regardless of, whoever that party is, that somehow there was something which was not disclosed at any point of time to the Commission. And therefore, on the material disclosure point, I don't see much of an issue. It was also within the parts of the Commission, unless I suppose somebody is making a claim that the Commission did not discharge, to again use my Sanskrit for today, which is competition dharma, and Competition Commission is supposed to discharge its dharma. I suppose unless somebody is making a claim that Commission has failed in discharging that dharma, it would be very difficult to suggest that any kind of a material disclosure or non-disclosure has taken place in this particular context, given that few years have passed and all transaction documents presumably were with the Commission.
Sure. Okay. Karan, I looked at some of the early cases of, let's say gun jumping or material non-disclosures that the CCI has looked into. And, I found at least two cases where, the Canada Pension Board and Renew Power case where the parties failed to notify an interconnected transaction. The Commission also penalized in another case, Ultratech, for classifying Century Textiles and Kesoram Industries as competitors, even though its promoter, the Birla family, held stake in these two companies. These seem to me, factual information, information that was hid from the regulator, which led to penalties in both these cases. Let me take this argument a little forward, that assume what the independent directors are saying have a case. It's not CCI's mandate to see whether there are press note or FDI regulations are being violated or not. Its charter is very simple: to look at competition in the market. Assume that Amazon told a story and CCI got swayed by it. Even then, the final sort of conclusion wouldn't be very different from what it was in 2019.
Absolutely. I think your question is in two parts. One is, can the CCI look at more broadly into areas such as the press note and determine that there has been a violation of the Competition Act? I don't think so at all. In fact, the CCI, and credit where it's due, has always shown a lot of, I would say, regulatory humility. Especially not only in merger control, but in other cases, for example, on data and RBI regulations on data localizations, etc. The CCI has always said, this is not my domain. There is a sectoral regulator. Let them handle it. And so clearly, as far as any potential violation of FDI norms in India is concerned, that is outside the domain of the CCI. And clearly, the CCI is going to restrict itself only to the Competition Act. To the aspect on whether the result would have been different if the intent was shown on the first place, or the intent was disclosed by Amazon to say my actual intent is to acquire or have some degree of control over future retail. I don't think that changes as well, because that's what the order of the CCI says. Later down towards the end of the order, where it says the competition assessment, they do that competition assessment on Amazon on one side and future retail on the other. And they come to that conclusion that because India is such a large market, both on the organized and the unorganized sector, wholesale retail sector, this is not going to make any material difference on competition. And therefore, from the stand of the Competition Act is concerned and what its mandate is to protect, it did not see a problem with the combination.
Sure. Rahul, do you also believe that the outcome wouldn't have been very different even if Amazon had said that, look, we are, and that's what my point is, that it's not like the shareholders agreement that, laid down the rights that Amazon is getting indirectly on FRL, if I can call it that, was hidden from the regulator. To your mind, would the outcome have been any different?
Not really, and I'll explain that a bit. I mean, I suppose, see, Competition Commission is a regulator which deals with market participants on a day-to-day basis. I would think that it would be safe to assume that every single combination transaction which is notified to the commission assumes that the transaction is there to make money by it. As simply as that. But I would assume that Indian Competition Commission is mature enough to understand that every single transaction is done because somebody wants to make money. And you talked about the coupons, right? You talked about discount coupons. Now, of course, Amazon must have been investing in coupons to make money. But of course, I mean, Amazon must be writing other things, including the restrictive covenants, which I'm assuming that everybody was able to read, including the Competition Commission, that in a schedule, there was something called restrictive covenant. And the restrictive covenants were also meant to make money, nothing else, right? Now, so long as that sort of an idea is clear, and I'm assuming that nobody is naive over here, neither Bezos and Amazon are naive, nor are the independent directors, and I'm absolutely sure the regulator, the commission is not. If nobody is naive, then it doesn't seem like we are really going to achieve much in difference of outcome in terms of combination order is concerned.
Okay, final question to you, Karan, that it's going to be difficult, right, for the regulator to accept that, hey, look, all these facts were disclosed to us, but now we didn't think it was going to be interpreted in this fashion, that Amazon will suddenly turn into a strategic investor and these negative rights will be exercised by it in this fashion. So it's almost admitting that we didn't do our job when these SHAs were submitted to us.
Actually, I think, I read it slightly differently. I think the CCI actually did its job. The CCI, the reason why the CCI has gone that one step ahead and actually done an overlap analysis with future retail is because it realizes that in the future, there could be, because of the nature of the interconnected transaction, the nature of how Amazon could perhaps influence future retail, that it's important to see how these two groups are coming together. So and having done that analysis, I think it's now very difficult for them to go back and say, I seem to have messed this up, because I would have understood that they're saying we missed something because it was not disclosed to us. And now that you are actually in the form of a strategic investor, I need to do that analysis today. But having done the analysis 3 years ago in 2019, today they can't go back. I think it will be very difficult for the CCI to go back and say, I missed something.
All right. Okay. So you both seem to agree that it's far-fetched that, CCI would have missed the actual intent of Amazon, whatever story was spun by, let's say, Future Retail, Future Coupons, or Amazon at the time. The regulator did do its sort of job, and it looked at the competition in the market and came to a conclusion that it will not cause AAEC. And very rarely it happens that both panelists on my show sort of agree to a particular situation. And let me also sort of tell our viewers how difficult it was to get two competition lawyers who are not conflicted on a deal of this size. But in fact, the why, and I'm sure you that's a question that is in everybody's mind, that why the independent directors, which Rahul also alluded to, are speaking up 3 years after the transaction. And why the independent directors and not Future Retail. And I got this theory from two arbitration experts, and I'd like to call that out, because the strategy seems to be, and their reading of the situation, that if a Future Retail would have been involved in the filings, so it's thought the independent directors have been sort of leading the charge on this strategy. And two, if at all Future Retail loses the arbitration in Singapore, it's possibly seeking an adverse sort of outcome at the CCI to then challenge enforcement on public policy grounds. That seems to be their reading of the situation. Do either of you sort of also hold the same view or reading the facts in a similar way?
Yes, and I think I would agree to both those, and I perhaps add a third, which may be a bit far-fetched, so I'll caveat it to that extent, which is to say, let's suppose your transaction documents had CCI approval as a condition precedent, which, if by some magical wand that approval were to go away, therefore a condition precedent is not met in the first place. So perhaps there may be some third aspect to it, to say that the conditions for closing never met, and therefore this may be some sort of void ab initio sort of argument. As I said, I footnoted by saying it's perhaps far-fetched, but considering what we see these days in arbitrations and in courts, nothing is far-fetched.
Okay, maybe shot in the dark, but independent directors of future retail are taking their chances before the regulator. And as both of you have pointed out, it might be very difficult for the regulator to go back on this approval or unwind the clock, so to speak. Rahul, Karan, many thanks for joining us here on Fineprint with your candid views. And thank you so much for watching.
Thank you.